All right. Welcome, everyone, to another episode of Lassiter Law. Here I am with my co-host, Top G, Lacey Gee.
I am here, and welcome to the badass that is Mark Lassiter. Is it okay if I call you badass?
Yeah, I think so.
Okay, because I genuinely think that you're a badass.
You know, if the shoe fits.
Yeah.
Yeah, my wife will tell you if my head got any bigger, I wouldn't fit through a door. But, you know, it is what it is.
I am so grateful to come here every week, and you just continue to amaze me with your knowledge and with all the info that you are sharing. I'm very excited to be doing this with you.
Well, hopefully we're passing this on to the audience, lawyers and clients or potential clients or individuals who just want to learn more. And today we have a special treat because I'm going to walk you through, we've been talking about DWI, Lacey, but I just got done with a trial. So I'm going to walk everyone through what we did in the trial, the strategies that we employed, and why we were able to come out with a victory.
Okay, so the trial has wrapped up.
Trial's wrapped up.
Okay.
All right, so let's start with the easy stuff, right? So we've talked about what happens when you get a DWI, the process, why it's important to do certain things, but I love practical application. I love teaching people this is how you put it all together. If you did your job right, this is how you win the unwinnable. So to give everyone a brief idea of the facts, we have a Spanish-speaking only driver. He gets into an accident by running a red light. It was a flashing red light, and the lady he ran into had a flashing yellow light. He runs the red light because he doesn't bother to stop. He T-bones her. Luckily, she's okay. Obviously, the police respond. They check on her to make sure she's okay, but she has to go to the hospital, but everything ended up being all right. Insurance took care of everything.
Good.
So there was no what we call restitution. So restitution is when, let's say, you get into an accident and insurance doesn't cover anything, and that person that you hit is out X amount of dollars because of the accident. Well, restitution in a criminal case, the courts can require that so that you make that person whole.
So if someone's insurance is not covering it, is it because that person is not insured?
It can be because that person is not insured. It can be like, for instance, if you get into a normal accident and both of you have insurance, then the insurance companies duke out who's at fault and who's going to pay. If you have one person who has insurance and one person who doesn't, then let's say I got an accident with you and I had insurance and you didn't, and it was your fault. Well, my insurance will still pay if you have what's called uninsured driver, right? Which most people do. If that person doesn't want, or they have like a medical bill or something else that insurance doesn't cover, then the state of Texas, as part of the criminal case, can order you to give me money to cover my costs.
Okay.
So whatever that, you're going to have a deductible. And like, no matter what, if I have an insured, I'm going to have a deductible for that, $500,000, whatever it happens to be. So the state of Texas can demand restitution. So in this particular case, there wouldn't be any because the insurance covered it. And when the police arrived on scene and they realized very quickly that he didn't speak English, the officer had a very limited Spanish vocabulary. And what they did is they called what's called language line. Now, language line was or is a company, and they have a bunch of interpreters on hand.
Okay.
So if you need them, no matter what time of night, the police agencies contract with them, and they call them up and they say, hey, can you translate for this, right? So they did that in this case. They translated what the officer was saying to the person that's being investigated, my client. And then he did whatever it is that the officer was asking him to do. In this case, field sobriety test, answered questions, things of that nature.
Okay.
After failing all the field sobriety tests, he did very, very poorly. Even if field sobriety tests didn't work, anybody looking at this individual would go, that person's pretty drunk.
Mm-hmm.
Then they asked him if he wanted to consent to a blood draw, which he did. And then after that, they got the blood, and the blood came back at a 0.23, which is nearly 3 times the legal limit.
I don't math. I was going to say double.
Yeah. 0.08 being the legal limit, 0.16 is double, 0.24 is triple. He's nearly triple. And to give everybody an idea of what that is in consumption, and we'll probably do an entire podcast on this, just this subject is alcohol consumption. Everybody thinks, 0.08, that's not that much. That's like 1, 2, 3 drinks. No, when you actually get down to the brass tacks, in this case, a 0.23 is equivalent of like 15 drinks.
Oh, okay.
And that's at the time of testing.
Mm-hmm.
Like at the time of driving, who knows what he was? He could be higher, could be lower, but at the end of the day, with the amount of time, it was like 4 hours before they actually took the draw. He's probably under any theory of extrapolation and how the blood goes out of the system or the alcohol comes out of your system, it's probably going to be higher, more than likely. Mm-hmm. So you have all these facts, right? And by the way, it's a DWI second offense.
Okay.
The first one was not that far before.
Okay.
So you look at all this and you go, well, Mark, why are you going to trial? Like, if you get punished, by the way, with a DWI second, and the first one was within 5 years, which it was in this case, you face a minimum of 5 days in jail. So even if you get probation, which is not guaranteed, the judge has to decide if you go to the judge for punishment, whether or not he's deserving of probation. So even if you get it, you have to do 5 days as a condition of probation. So that's 5 days in jail on top of whatever probation requirement you're going to have, which is likely 2 years with the interlock device on your vehicle the whole time.
You've mentioned before that 1 day counts for 3 days.
That's only in Dallas County.
Okay. But does anything like that apply
That
here?
does not apply.
5 days, no matter what.
And it's just so people understand, every jail has different credit that they give you. Some jails, if you do a day, that counts for a day. Some jails, because they're overcrowded like Dallas, if you do 1 day, it counts for 3 days. Some jails give you what's called trustee status, and so 1 day counts for 2 days. It just depends.
Okay.
Every county is different. Every county's allowed to do it differently. Dallas County is the one who is 1 for 3, but when we talk about jail time as a condition of probation, that is day for day. That is 1 day equals 24 hours. That is day for day.
Okay.
So you would have to do these days. So most people go, and the prosecutors in this case asked me, well, why are you going to trial? Like, you're not really going to trial on this. And I said, well, yeah, we are.
What he's not saying is, I'm a badass. But
well, we're not telling them what our defense is. And then we'll get to that in a minute. But so the process, those are the facts. And the process that happens is we actually did a motion to suppress on it, challenging language line, because language line we found was not giving a true and correct representation of what was being asked to be translated. So if I told you, hey, do you consent to a blood draw? And I'm reading that DIC warning that we have talked about that contains a lot of legal language, and they don't translate that correctly of what can happen if you give a blood draw, what happens if you don't, then it can confuse the mind of the individual, and that can override your consent, because now what we argued was it wasn't informed consent.
So there's a transcript with this language line.
No. There's no transcript.
Okay.
It's just on camera. It's on a body cam.
Okay. They can hear both ends of the conversation?
The defendant or the person being investigated, which becomes the defendant, can hear the translator on the phone giving them instructions.
Okay.
They can also hear the officer giving those instructions in English, and if they don't understand English, they wait for the Spanish, and then basically what you have is the person trying to accomplish the task that they are being asked to accomplish, which is field sobriety test, or in this case, should we give a sample of our blood? Mm-hmm. Now, when we did the motion to suppress, we did it on the basis of the translation overrode our consent, because in a blood draw, your consent has to be voluntary. Let me ask you, Lacey, if I give you some information, but not all the information, and if I had given you all the information, you would not have made the same decision. Is your consent to me voluntary?
Without all the proper information, no.
Right. Mm-hmm. And the law works the same way. So if I come in and I try and trick you or coerce you into agreeing with me, then it's not real consent, because it's not informed consent, right? We don't want our officers going out there and saying, hey, just give me this, it'll all be okay after, right? That's not the law.
Story.
And there is cases directly on point that say you need to give this instruction in this manner and in this specific wording. And if you don't, you have the potential of coercing the defendant or person into agreeing with you. So we did this. We lost the motion to suppress. And rightfully so, because when it is consent, the burden is on us to prove that there is a problem, and then the state must prove that the consent was in fact voluntary. The state always has the burden to prove consent is voluntary, but we have the burden of presenting that there is something out there that coerced the consent. All of this just to say the translation was the issue. And if you were a good DA and you were preparing your case properly, this should trigger something in your mind. Consent is a problem because of the translation. See, what they were focused on was consent. What I was focused on was the translation. Let me ask you, Lacey, if the translation for the consent was a problem, what do you think the rest of the translation might have?
Questionable.
Right?
Oh, okay. Sorry, but I have a question. So there is a Spanish-speaking person in court who's listening to everything that's being transcribed from this phone call.
So when you have when you have a Spanish-speaking only that cannot, even if you speak English, but it's limited, you have a right as a citizen, or not a citizen, by the way, this guy was not a citizen, you have a right as a defendant in the criminal justice system to have the information that's being spoken about in the trial transcribed to you. So there is a court-appointed interpreter who sits right next to the defendant who translates everything that is said. They have a number, they have a license, they're certified so that the court knows this is a true and correct representation and interpretation. And in fact, they swear to it that this is a true and correct interpretation. But that person is just for the defendant in the courtroom. They are not witnesses in the case.
Okay.
So, and you've touched on it. A smart person would go, hey, there might be a problem with the translation in this case. They've already touched on this prior to the trial. So we show up for the trial. We're ready to go, and we pick a jury. And we'll do a whole, probably 5 or 6 episodes just on jury selection. Ladies and gentlemen, it is the most important part of any jury trial. The worst lawyer in the world can beat the best lawyer in the world with the right jury. And if you don't have the right jury, then your arguments can fall on deaf ears. So that's the first step, is we picked a good jury. The next step that I made sure to do, lawyers, you must do this, is you must get the jury sworn in. Jeopardy does not attach in a jury trial case until the jury is sworn in. Why does that matter? Right? Why did it matter in this case? Well, because we had certain issues that we wanted to bring up, that if we did not bring up with the jury sworn, then the case can just be continued, which we don't want.
So a jury is not sworn in every time? I thought, watching it on TV, that you take an oath every single time. Okay,
so the jury takes an oath first before jury selection to tell the truth. After they are selected to be on the jury, then they take an oath to follow the law. 2 different oaths. Now, that oath to follow the law, that is swearing you in. The oath to tell the truth is not. Now, why this matters is because, and lawyers pay attention to this, if you have an issue that the prosecutor's office will realize because you bring them this issue prior to having jeopardy attached, all they have to do is ask for a continuance. And most of the time the judge will grant it because the jury has not been sworn in. If the jury has been sworn in and jeopardy has attached, and then they ask for a continuance, the judge has the right to grant that. But now you have what's known as double jeopardy. Now, it doesn't apply in every case. Every case is different. But you at least have the argument that the reason they were giving, and by the way, you have to do a mistrial at that point. So it's not really a continuance. The judge has to mistry the case for one reason or another. They have to state the reason and then give the state a continuance.
Okay.
So if you have a mistrial and the reason is the state wasn't ready because they were negligent in their duties, there are cases that indicate that is negligence is the akin to willful conduct. And if you have willful conduct that causes a trial to end in a mistrial, then judges are then allowed to rule that it is double jeopardy and the case is precluded from going forward. So, moral of the story, get your jury sworn in before you tell them what's wrong with their case. So keep in mind all the facts we have. 0.23, accident, looks terrible, can't speak English, DWI second. All bad. There's nothing good about this case. Then I get the jury sworn in. And then I ask the judge to have the jury step out so that we can do a motion in limine is what we call it. A motion in limine, ladies and gentlemen, is telling the judge, please don't let the other side talk about these particular issues, because if you do, it has the potential of letting bad evidence in front of the jury that may not come into evidence and causing a mistrial, because that bad evidence is so damning that if you remove it, the jury cannot ignore it, even though they're supposed to follow the law and ignore it. They've already heard it. Cat's out of the bag, right? For instance, if a jury hears that this is a DWI second offense, they're not allowed to hear that because they are supposed to make this decision based on the facts of this case and this case alone. And if they heard about a fact of another case, which is the DWI second, then that would be in their minds, well, he's done it once, he's doing it again, right? They would be more likely to convict, and you don't get a fair jury.
Okay.
So they're not allowed to hear it. So imagine a scenario where that comes out. The police officer just blurts out, well, this is his second offense, so, that came as part of my investigation. Well, then the jury's heard it. They're not supposed to. We did a motion in limine saying, Judge, don't let him talk about that. Judge granted that, but now the cat's out of the bag, and the judge has to literally declare a mistrial. And then, like in that scenario, you say that was willful conduct, double jeopardy applies, this isn't just a simple mistake, and the judge has to decide whether or not the trial can go forward. But all of this to say, in this case, what we did is we sent the jury out and then we raised an issue. The first issue that we raised is that the translation, the person that was on that language line, needs to be available for trial. Lacey, do you think that they brought the translator to the trial?
No, and this translator could be anywhere.
They don't even have their name.
Oh, okay.
They just have somebody that was on language line.
Okay.
So the job of the prosecutor at that point would be to make sure that, because if they were thinking, I've already challenged the translation being correct. If I was a prosecutor, I would have brought someone from language line, that person, in fact, to say that they translated correctly. I would know that that's going to be an issue in the case. They did not, because they did not prepare. Because, ladies and gentlemen, young lawyers have to learn, and sometimes they have to learn the hard way. And I got asked this after this case, how can you represent somebody knowing that they're guilty, knowing that they did something bad like an accident, knowing that they're 3 times the legal limit? And I said, lady, and this was talking to a couple of ladies, the most important thing that I can express to you is, if this happened to you, your son, your daughter, your friend, do you think that they're entitled to representation? Does our country entitle them to that?
Very much so.
Do we want that to continue? I would say we do, right?
Yeah.
Do we want the lawyer that is given to them to be the worst lawyer ever? Or are they entitled to the best lawyer that they can either afford or the court appoints? Should the lawyer, in other words, do a good job?
Mm-hmm.
And if the lawyer does a good job and happens to find mistakes that are made and they win on those mistakes, does that make that lawyer a bad person?
No. Also, you didn't create the justice system. You didn't create this to happen in the first place. This is something that...
Sure.
Yeah.
But at the same time, we talked about in a previous episode, John Adams, and how he got his start was representing, an English soldier accused wrongfully. And he was court appointed, and he did a good job. That doesn't mean that if you have a person that has done something wrong, they are not getting punished for what they did. Because going through the process, and I encourage you to look at the previous episodes, I believe episode 2, we talk about the process of DWI and what it takes to go through that. It's not an easy thing. You're not getting out of this scot-free, no matter what. If you're paying a lawyer or lawyer's court appointed, you have things that happen to you. In this case, he had what's called an interlock device on his car since he bonded out of jail, which is something you blow into to ensure that you're not violating the law again, and it makes sure that you cannot start your car without having no alcohol. But all this to say, we talk about how can you represent somebody that either or you think did something wrong. Well, the job is not to determine whether or not, as a lawyer, they did something wrong. That is not your job. As a defense attorney, your job is to look at the evidence and not lie, but present the best defense that you can. Now, if that happens to win because 12 people decided that there was not enough evidence, or the prosecutor's office decided that they didn't want to go forward, or the judge decided that this case should be thrown out, whatever the case may be, your job is to actually present a defense based on the law. You do not have to be a liar. You do not have to present something factually incorrect because your client wants you to. You do not have to present their side of the story if their side of the story makes no sense. Mm-hmm. But they are entitled to a defense the best that you can provide. In this particular case, our defense was not that he didn't do something wrong. Our defense was this, when it came to this, and this is the specific area that I'm asking everyone to concentrate on. These are the details that matter, the attention to detail that I see that is lacking throughout society. I'm trying to teach it to my children, but it's just not taken because nobody seems to care about the details. It is simply get the task done as best as you can. Well, if as best as you can is ignoring the small details, then you didn't do the task well. Mm-hmm. I find that we need to encourage people to do the task well. And if that means going back and redoing it, it's kind of like when I was told to make the bed as a kid. If it didn't look good, my mom sent me right back in the room to make the bed again. Mm-hmm. She didn't tell me how to make it. Mm-hmm. She said, get it done. She showed me the first time and that's it. All right. So we're here, we're in the trial. We ask the judge, we have a right to cross-examine. So under the law, there's something called the Confrontation Clause. Confrontation Clause means I get to confront the accuser. Now, it doesn't always mean that that's a police officer who is accusing you of doing something wrong. In this case, it's anyone who has any statement that is potentially that they can foresee being used in a criminal case. So in that situation, what you do is you say the translator is making statements on video. Like, let me ask you, Lacey, just as a regular person, if an officer is speaking to a translator and a translator is speaking to you, who is telling you what to do?
The translator.
The translator.
Mm-hmm.
How do you know that the translator is telling you exactly what the officer is saying? How do you know they're actually translating?
I wouldn't, because I only speak English.
Right. Mm-hmm. So in this case, the defendant only spoke Spanish. Mm-hmm. He doesn't know what the officer is saying. He is only listening to the translator. So the translator is making statements. So we argued that those statements are subject to cross-examination, which they are, and without that person available to ask, did you translate correctly? And then we could point out the ways in which they did not translate correctly because we were ready, because we hired a Spanish-speaking translator and said, is this correct? And it wasn't. So we were ready to cross-examine if they brought that person, but they didn't bother to bring that person.
That was my question. That was how is it being determined that this was wrong? Because if someone, like I just said, if someone's speaking another language to me, I have no idea. So are you just guessing? But no. So you were...
No, we don't just guess.
you were locked and loaded. Well, I mean, I'm saying I'd be guessing. Do I know what they're saying?
Well, everybody,
not.
That's right. Everyone who did not know, right, Spanish, would be guessing at what the translation actually was. They would not know one way or the other whether it was correct. Now, us being prepared, attention to detail, we were prepared to present evidence that it wasn't. However, when they failed to bring the person that was making the statements to the individual being accused at that time, being investigated, we now have no way to cross-examine in front of a jury, because I can't just put somebody on and say those statements are incorrect. I can if that comes into evidence, but my argument was it shouldn't come into evidence, because everything related to that person under the confrontation clause, if they are not available to testify, is inadmissible. So what happens to the entirety of the investigation if the entirety is based on language line, a person that's not there? It's now gone. They now have no evidence of field sobriety testing. All they have is what he said when responding to the officer in English. It's basically, I don't speak any English. So how are they supposed to get any evidence into and in front of a jury to indicate guilt? Because they don't have that person. So with that, they had a problem. Now they don't have enough evidence, but they still have the blood test. Here's the other thing about attention to detail. When you do a blood test, they have documents, data that support the accuracy of that test. So they're going to have chromatographs. They're going to have all kinds of different things. It's probably about 100 pages worth of information that tell you, the expert, whether or not they did this right, did they do this right, did they do this right, and they check all the boxes all the way down. Well, if you don't have that, then I don't have anything to give to an expert of my own to say, hey, did they do this blood test correctly? Is this an accurate result? And we'll talk about blood tests in another episode, but in that particular case, I suggest since we don't have the evidence, they didn't provide it to us in a timely manner, and we had requested it 1.5 years ago, that should not come into evidence. And they tried to make some arguments that, hey, this we can get around it this way or we can get around it that way. But at the end of the day, you know what they did?
What?
They dismissed the case. So he walks away from there, and it's not scot-free, ladies and gentlemen. There are still things that happen to a person when they have a DWI. But he is now not convicted of a DWI second. He is now not going to go to jail. He is now not going to be deported, because typically in an immigration case, they have the right to deport you on a Class A or misdemeanor or above, which a DWI second is. Remember, we talked about in an earlier episode, Class A is a DWI second or above a .15, which this was both. Now it's neither. And, you know, irrespective of whether or not he should be deported because he's here illegally committing crimes, that's a different topic altogether. Now, whether or not I agree with him being deported, again, different topic altogether. Because what we do is we don't look at those things. Our job is not to say, we believe he should be deported, so we plead him to the thing politically that we believe he should be convicted of so that he will be deported. No. If you do that, it is as unethical as it gets, and you shouldn't have a law license. We gave him the best defense that we could. It ended up being a successful defense. And
because of that attention to detail.
Because of attention to detail. And that's why we go back to when we talk about, I think it was in episode 2, who to hire. You have to find someone that you can trust that is going to pay attention to those details, because if they don't, they will miss ways in which they can win this case or win that case. And it's all because they failed to do the work. It's not that it's hard. It is that you have to actually do it. You have to find those things that we're going to talk about on these episodes. And in fact, if you listen to these episodes as an attorney, I will teach you how to defend cases with the attention to detail that you need to win, to be successful. And I'm not telling you you're always going to win because you pay attention to detail, but I'll tell you this, you'll win more often than not. Because the other side, unfortunately, is overworked and underpaid, and they do not have the time to pay attention to the smallest of details that you are paid to do, because they have thousands upon thousands upon thousands of cases with no end in sight, because crime is never going to stop. So for every case that they get rid of, they have 100 waiting in the wings. You, as a individual attorney that is representing clients, have the ability to dedicate the time necessary, maybe much, much, much more time than the prosecutor has to dedicate to it, because they've got 3 cases set for trial that week and you're just one of them. Heck, when I was a prosecutor, I used to have 10 cases set for trial per day. Lacey, let me tell you what DWIs used to be like, right? To take a side note.
When is this used to?
This is 20 years ago.
Okay.
So DWIs didn't used to have breath or blood. They didn't have BAC scores, because you remember the slogan, just say no, right? It wasn't just say no to drugs, say no to everything when it came to being pulled over. Everybody knew it. Just say no. Say no to breath, say no to blood. They didn't even bother to try and ask for blood. So back in 20 years ago, and say no to field sobriety tests, if you got pulled over and the officer said, hey, I need you to step out of the car and do these tests, you just said, nope, not doing it. And then, do you want to take a breath test? Nope. You could do that because they can't force you to blow. They can't get a warrant to force you to breathe. They can get a warrant to take your blood because they can physically take it without you being willing to. They can hold you down, but they cannot do that for breath. It will not work. So you could have zero evidence in these cases, and they were back to back to back to back. And there were hundreds of thousands of them, if not millions, across the country. And so what we would be backlogged, because we would try and get the defense lawyer to plea when I was a prosecutor to these cases. And he goes, why would I plea? You have no evidence. And they're right. So you know what? We had as a choice, a prosecutor, we can let this person go and basically dismiss a case because we don't have very much evidence, or we can try a case we know we're probably not going to win. But MAD is a very powerful organization, and they support political figures. And so you can't just be known as the district attorney that doesn't have enough evidence and just dismisses everything. So you go to trial and you let the jury decide. And we would have literally 10 cases set for trial, Monday, Tuesday, Wednesday, Thursday, and then Fridays were trial before the courts and motions to suppress. But literally, you'd have 40 cases set for trial in a week. And you, the prosecutor, had to be prepared on all of them, knowing what you're going to do. I can't tell you the number of times that I was willing to go to trial at the drop of a hat, because I knew I was in the prosecutor's office to learn that we would get a case. I would never have seen a single fact in the case. I will walk in after a jury had been selected, sit down and say, tell me what happened, having no idea what actually happened. That is the level of preparation that we had time for back in those days. Now that has changed. Now, because of blood tests, people don't go to trial as often, so the prosecutor's much more prepared, and you have a lot more paperwork that indicates whether or not somebody did something or not, and you have proof, right? It's very difficult. In spite of winning a lot, it's very difficult to overcome a high blood score. It's because people tend to believe it. Let me ask you, Lacey. Let's say you're on the jury.
Okay.
And you hear that there was an accident, and then you see field sobriety tests, and let's just say they don't look too bad on them, but you see a blood test that's a 0.15, which is nearly double the legal limit. Now, I might introduce evidence to indicate that there's some things that might be wrong with the blood, but at the end of the day, you're going to hear from an expert, and the expert's going to say, no, those things don't matter, the blood's accurate. You're probably going to tend to believe the blood test is right.
I would.
And then you're going to convict him. And you're going to convict him because you're like, look, I didn't have any evidence indicating that the blood test was wrong. The expert said it was right. You didn't present an expert. Well, that's when you get a lot of people that get found guilty. And so these cases don't go to trial as often. And the trial cost is more because you know it's going to be a 2-day trial, not a 1-day trial. So at the end of the day, you've almost eliminated, and the legislature also gave a way in which you could reduce the DWI from a Class A to a Class B, and there's a way to do deferred now, so you can get DWIs off your record. You never used to be able to do that, so it encourages more plea bargains. So DWIs, especially with the things that are happening as far as the legislature and the laws that are changing and the I think the landscape of driving while intoxicated with Uber and Lyft and all those, there's just not that many of them anymore, right? You don't have hundreds that are being arrested. There used to be 600 arrests by DPD every month for DWI. Now there's like 20, right? That gives you an idea. But that is, in a nutshell, I know we went on some sidetracks there, how you can take an unwinnable case and win based on attention to detail. But if you don't know all of the things leading up to and how to make sure that you get your jury sworn in, how to present and when to present your evidence to exclude, your motion to exclude evidence to the judge, how to present that argument, what cases to rely on. If your attorney doesn't know this, 9 times out of 10, that person loses, goes to jail for X amount of time, and then gets deported anyway. Because what likely would have happened if we had lost the trial is he does his time in jail. They realize it's a Class A or above. He gets reported to immigration. Immigration then sends him away, so he can't complete his probation. Then a warrant gets issued for him so that if he ever goes anywhere or tries to come back, he gets picked up at the border. Unless, of course, you're coming over on one of the buses and they give you $1,000 in a phone. You know, I've heard about that. Don't know if it's true or not, but I've heard about it. But that's just an example of what could have happened if he had not had an attorney that had attention to detail.
And I appreciate the fact that you explain people have the right to a defense. Your defense is not that this person or any person is not guilty. Your defense is to look at the evidence, pay attention to detail, and present that.
It's exactly right. And Lacey, let me ask you something. Does it matter for your representation if they're guilty? Should it matter?
No.
Right.
No.
And most of the time people ask me, well, do you know? And I say, no. Well, that's not my job. That's the jury's job to determine. Now, if they want to tell me, I want them to tell me everything that happened, and I want them to be honest with me, right? So one of the easy things is drug dealer comes in and says, you know, I was selling drugs. Okay. Most drug transactions don't go to trial because either you had the drugs on you or you didn't. It's pretty simple, right? Or you do what's called a motion to suppress, saying they got to those drugs illegally. So most drug cases don't have trials. The reason they have trials is if, for instance, I have this one case where it was in somebody else's backpack who had just gotten in a car, and they charged everybody in the car because, of course, when he pulled over, ladies and gentlemen, don't do this. Don't smoke weed in your car. It is the easiest way. I know I've said it in other episodes, which the cops have the right to search. They do. You are giving them probable cause to search your vehicle for anything and everything. So anyway, these two yahoos were smoking dope in their car, right? Then they get pulled over. Cops search the car. They find the backpack. They find the 2 pounds of marijuana that are in the backpack along with the gun. And they say, is this yours? He's like, no, man, that's not mine. That's his. And the other guy's like, yeah, man, that's mine. And the cop's like, well, we're going to charge both of you. In that case, you don't have possession. So the case will come down to, when we talk about drugs, whether it is constructive possession because you know it exists and it's in your vehicle, or it's actual possession, right? That's a horse for a different day.
Yeah.
But at the end of the day, what I'm trying to get at is sometimes you'll know if they did it, sometimes you won't. But attorneys, you don't have to ask the question. The question to ask is what?
Can they prove it?
Can they prove it? Can they prove the offense? That is what you're concerned about. Can they prove the offense? And they may be that they can prove the offense if they do everything right. Just like in the example that I just gave you. Had they done everything right, they could have proven their case. I would have had no defense. I have often said this. If the justice system did their job, like the police and the prosecutor, I don't have one.
So if you're going to trial, if you tell your client that it's best for them to go to trial, that's because you have evidence, attention to detail, something that you think can be beat in court, if I can say that.
Not necessarily. I mean, that's what people think, right? Is that you don't go to trial unless you think you can win. Not true. The reason that's not true is sometimes you go to trial because the punishment range is not appropriate. So I'll give you another example. Let's say that you have a young man, right? And this is actually a hypothetical that is currently happening. We're set for trial right now. The offense is not good, right? It's a bad offense. It's a DWI third or more. He is way over the legal limit. He did have an accident. And since we're talking about DWIs, I'm using this as an example, but there are many other examples where in a sex case or a juvenile case or a drug case, this is the same, where the recommendation in this case happens to be probation, but it makes him a felon. Because if you accept a DWI third or more as a plea, he will be a felon. So he'll be a convicted felon for the rest of his life, and he's a young man. Mm-hmm. I don't believe that's the appropriate punishment. I believe that treatment might be better, and years of probation is the appropriate way to do that with some conditions for alcohol specifically. Now, they're going to tell me, well, he's done 2 other DWIs and that hasn't worked. Well, that's not necessarily true because every DWI is different. Well, maybe the first one, he was 18, young and dumb, right? Mm-hmm. The second one, there was another offense that was tied to the DWI, and we only agreed to plead to the DWI because we were getting a dismissal of a felony offense that should not have been there, mm-hmm. right? Because now we can't fight the DWI because the goal is no felon. Well, now we presented enough mitigation evidence, mitigation being things that he's done right, that the prosecution can consider and say, look, we need to give this guy a break. We need to reduce it. Since they won't reduce it, then the option is trial or not trial.
Okay.
If I don't want him to be a felon, I have to go to trial. It's not because I have a good case. It's not because I anticipate winning. It's because there's nothing that is going to harm potentially if we go to trial. In other words, there's no risk. If I have a case which there's not a good defense, and yet I don't agree with the appropriate punishment, and there's no risk to going to trial, well, then we go to trial because of the risk factor. The whole point of the plea bargain is it's supposed to be a bargain. If they don't give me a bargain, then there's no reason to take it. Mm-hmm. And in this case, there's no reason to take it because it's not a bargain, because I can get probation from a judge or jury. I'll end up with essentially the same level of probation. So what am I gaining by a plea? What you're gaining is I'm becoming the convicted felon that I don't want to be, and I'm giving up my rights that the jury might find me not guilty. It doesn't matter that you don't have a very good chance, mm-hmm. but you're giving up the chance. That's the thing. And to give up that chance, the prosecution needs to understand they need to give you a bargain to make it worth your while. If they don't give you a bargain, lawyers that are out there, there's no reason to take it. Now, let's flip it. Let's say that the offer was prison, and the person that we're talking about is not eligible for probation. In that particular case, obviously you set it for trial because there's no risk. Mm-hmm. But you change one little thing, like now we're offering probation, but if you go to trial and you lose, you will get prison. Now the risk outweighs the reward, and we take that into account.
Okay.
So sometimes we go to trial when the risk is not outweighed by the reward.
But if this hypothetical, if they were to go to prison, but that could keep them from being a felon.
If you go to prison, you're a felon.
Oh, okay.
Yeah, there's no ifs, ands, or buts. So you cannot go to prison without being a felon.
Okay.
That's what prison is.
Okay.
Jail is for misdemeanors. Prison is for felonies.
I did not realize that,
Yep.
obviously.
So if you go to prison, because there's a difference between jail and prison. If you go to prison, the only way you get there is because you're a felon, because you were convicted as a felon. And that prison sentence can be used to enhance any other future crime that you do. So if you get another crime, so to speak, that's a felony, they can enhance it one level because you've been to the pen before. Probation, they can't do that. So there are many, many, many risks associated with going to trial, and you have to evaluate those. But you do not always plead just because you don't think you can win, mm-hmm. right?
Yeah, because my question was if I did not realize any of that, obviously, but I would think if you're going to trial and what I said was true, that means that you have evidence to argue, that would cause the other side to be more prepared. But like you said, they're weighed down with a lot of many other cases, so they're not necessarily prepared. I would think
not all the
for that
time.
information, then I would think if they're going to trial, I need to do my work and my research.
It's person to person. So, some prosecutors are excellent, right? Which makes you wonder, why are you still a prosecutor? Because you could do such a good job on the other side. And then the pay is not commensurate with the amount of work. Let's be honest. These prosecutors, they should get, I remember when I started, it was a paltry. I mean, you could barely live on the salary that they were giving you, and they expected 60 hours a week worth of work. And it's very difficult because you're arriving at, for me, I got there at 7:30, and sometimes I didn't leave till 7 at night, and that's 5 days a week. So you're not really getting paid commensurate with your time, which is why a lot of people don't stay very long at the prosecutor's office, because it's hard to exist on that. But there are a lot of people that do. And as they move up, you move up based upon, supposed to be seniority, experience, and how well you do your job. Some places it's different than others. But I will say there are a lot of good ones. It's kind of like with police officers. When you sprinkle in a few bad ones, it just makes everybody else look worse. Mm-hmm. And then you stop trusting them. And one of the problems that I have is prosecutors sometimes have the tendency to become persecutors. And we talked about this, I believe, in the last episode, but you cannot, with no life experience, expect everybody to be perfect. Mm-hmm. You have to have some empathy. And without that empathy, the system doesn't work. And right now it's not working. Right now there is just a lack of empathy across the board. And that's why your jails are full. Mm-hmm. Because we think somehow jail is the answer, because politically it helps us get reelected, or it helps us save our job, because our boss says that you need to offer this rec. Prosecutors take an oath to do the right thing, not just to seek convictions. They take an oath to do justice, right? Whatever that happens to be. And I used to get in trouble all the time because my version of justice differed from others. But I was always true to my version because I thought I was doing the right thing. Whether or not, and it could be the opposite. Somebody may want the case dismissed, and I'm like, no, that's not the right thing to do. I want to push forward. So you have to have the ethics to stand your ground. Mm-hmm. But all this to say that, yes, there are instances that we go to trial and not always having good facts. It's just we're looking for a different type of punishment. If we thought the punishment was appropriate, we would take it. Right?
And that's why you want to get a good attorney that has your best interest, that treats you, views you as family, would take care of you like family.
If they don't, then they're not going to pay attention to detail. Mm-hmm. They're not going to seek every way. Clients always ask me this, are you going to win? And I said, no, I can't guarantee that. Ethically, I can't. I'm not the judge or the jury. But I do guarantee you this. If there is a way to win, I will find it. We will do the work to make sure we uncover every stone. We dot every I. We cross every T. We make sure that the law is followed. We make sure that we find a strategy that can work. Even in the case that I just described, where we don't really have a good case, we will find and develop a strategy that we believe has a chance of success. Now, whether it works or not, that's up to the jury. Mm-hmm. But keep in mind, the good lawyers know how to empower a jury. The good lawyers know, even if you have a bad case, when you're talking to that jury in opening statement, you tell them, we're going to go on a journey together. Because I guarantee you this, one side will tell you they know the truth. Doesn't matter what the truth is, they will tell you they know it. And the other side will say, look, let's explore and find out together if this is actually truth, or they're just telling us to believe it. Mm-hmm. And the problem is that the jury will see throughout a trial that the prosecutor's office will present something as fact that isn't. There's no need to do that, but they will. And then you look like the reasonable one when you come along and say, look, here it is. I'm not sure if this is a fact or not. It's possible that that's a fact, but it's also possible that it isn't. And if it's possible that it isn't, who does the benefit of the doubt go to, Lacey?
The person presenting the evidence.
That's the person that is charged. Mm-hmm. So the benefit of the doubt always goes to the defendant, the person that is accused.
I'm sorry, I took that as who do you believe as the jury? Then I would be believing the one who is presenting the evidence.
So if we give the benefit of the doubt to the defendant, and this is an assumption, not a fact, or this is an opinion, not a fact, well, then I have to throw that out with the bathwater, right? Real simple. And so you develop that, and as a defense lawyer, you need to be able to utilize different strategies. And that may change. The prosecutor may do the right thing and not overpromise, which is what they should do. When I was a prosecutor, I would just present, here are the facts. This is what happened. You choose. And you got to live with that result, because that's what the jury's for. It worked. If they found somebody not guilty, guess what? The system worked. Don't get upset about it. Your job isn't to win. Your job is to present it to the jury and let them decide. So as a prosecutor, you should never, ever be upset that you didn't win, because that isn't your job. Your job is to do justice, which is present it to the jury and let them decide. And when you present something as fact, or you do something just to win, like say some of the prosecutors have been in trouble for hiding evidence. When you do that to win, you have only hurt yourself. And you have proven that the system cannot work, because a system that is based on the honesty of the people in it doesn't work if you're dishonest. So I encourage every one of you out there, if you're a prosecutor listening to this, hold true to your ethics. Don't try and win, try to do justice, whatever that happens to be. If you're a defense lawyer out there, don't change your defensive theories or strategies based on whether or not you think he's a good person, bad person, did it, didn't do it. Do it based on the law. That person's entitled to defense. And if you don't like that person, don't take their case. And if you're on the case and something comes up, you're always allowed to go to the judge and say, hey, we just don't see eye to eye, me and the defendant. I need off of this case, because I need someone who can represent them without these different biases. So I leave you with that, ladies and gentlemen. At the end of today's episode, I want you to think about ethics. I want you to think about the practical application about how things work and how you can win seemingly the unwinnable. And we've just given you an example of that.
Incredible, badass Mark Lassiter. Thank you so much for this episode. How can people get a hold of you?
You can get a hold of me at www.lomtl. It'll be at the bottom of the screen on the YouTube channel and on TikTok and all the other Facebook platforms. You can also reach me at 214-845-7007.
Thank you so much, Mark Lassiter.
ProPod Digital.